I respond to Attorney Sharofsky?
Yes.
Legislative history only becomes an issue when there's ambiguity. There is no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons. So you interpret the statute in a way that makes sense. And the way that it makes sense is that simply because he's 17 does not automatically negate 2A.
Well, you know, I raised it earlier in the case. And it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I don't think so. The penal laws are construed strictly. Vague laws are... Who is that emperor from way back in history who posted the laws on pillars so high that the people couldn't read them? And that's been used by lawyers and judges for centuries about the requirement that people be given knowledge of what the law provides. And the basic law, and it's chipped away a lot of times with the appellate court decisions that are made on the subject of efforts to preserve the statutes, because some of them are quite messy. And that's not a criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to acquaint herself with what this law says?
Judge, there's testimony that the defendant, Mr. Black's stepfather, the defendant's mother, all knew he could not legally possess this gun. That's why he was kept up here. That's why Mr. Black bought it. This 2A is very clear.
For interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
You just said it should be clear to normal everyday people, and it was clear to these normal everyday people. Because it's very clear that under 18 cannot possess a dangerous weapon.
They don't know the law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
I'm simply responding to your...
Well, but the point is, you know, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse, so people are charged to know that, unless it's written on the top of a pillar so high people can't see. That people, if they're given legal notice, that's why they publish them in the newspaper. If people are given a legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right. I can tell you I've put many hours into it, so have you. And how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
Because 2A is very clear.
I wish it were to me.